Greetings and welcome to Understanding Evidence, Relevance. And if notifications get out, let's get started. And we'll be going into, just one moment here, let me get on to the, zoom in here a little bit more. And we left off from judicial notice, presumptions, and now we're on to relevance. Give some time for everyone to show up here. Make sure the notifications got out. And let's get started. Relevance. Relevance is probably one of the most widely understood concepts of evidence law, and yet the most argued. Lawyers fighting to get evidence in or keep it out are ultimately called upon to argue relevance of the evidence in question. What is relevance? And before we get into what relevance is, I just want to remind everyone this broadcast is strictly for entertainment, educational purposes, not to be construed or used for any professional, personal, legal, lawful, financial, or tax advice. Don't do this at home. Let's proceed. To paraphrase a definition given by the Federal Rules of Evidence, relevant evidence is evidence that tends to prove or disprove a material fact. So, what is a material fact? Let's suppose you're involved in a traffic accident wherein you rear-ended another car while wearing flip-flops on your bare feet and carrying your girlfriend's picture in your wallet. The flip-flops might have caused your feet to slip off the brake pedal. The picture in your wallet, though you may have been daydreaming about your girlfriend at the time of the accident, cannot reasonably be considered to have any bearing on the matter. The fact you were wearing flip-flops at the time may be material to the outcome of the case. The fact that you had your girlfriend's picture in your wallet probably isn't. If a fact is not material, then evidence likely to prove or disprove such a fact is not relevant, and therefore is not admissible. It really isn't and clearly shouldn't be any more difficult than that. Relevant evidence, an example, evidence likely to prove or disprove a material fact, is generally admissible. Irrelevant evidence isn't. Evidence is only properly admissible when its introduction is reasonably likely to prove or disprove a material fact. If the fact that may be proved by offered evidence is not material, an example, if it will not tend to decide the case one way or another, then the evidence is irrelevant and should not come in. Sad fact, however, is that many unscrupulous lawyers, in their mad haste to make as much money as possible in the shortest length of time, regardless what may or may not be true or just, introduce irrelevant evidence in an effort to prejudice the court. Such irrelevant evidence may seem to address itself to some material fact. However, on closer examination, it is found to be nothing more than smokescreen to hide the truth. An example from a real case follows. All right, so let's check the chat before we get on to the real case here. Hey, Captain Jack, greetings. Evidence is the past. Tomorrow I don't know about. Law is a measurement created by humans to dictate right and wrong, or I win and you lose. Well, and law really should be the rule of right, and we always want to be on the side of right. So let's check out this interesting story here. A very successful multi-million-dollar business operated almost exclusively upon its use of certain trade secrets, without which it could not have made a dime. The CEO of this company met with the owner of a competitor company and agreed The two of them would create yet a third company that the competitor would eventually purchase for a substantial sum. By paying the CEO millions, of course. The CEO, in turn, stole the trade secrets, left his once successful employer, and started the new business with a great deal of financial support from the competitor, who looked forward one day to owning the trade secrets and the new business while the CEO enjoyed the millions he was promised. After the victim business owners filed a lawsuit to recover damages from the CEO and the competitor, the defendants claimed the victim business owners had prior dealings with a man who had gone to prison 6 years prior, and alleged that because the victim business owners had once dealt with a man who was now a convict, that they should not be permitted to sue the CEO or the fund-providing competitor, insisting on introducing evidence of the prior dealings with this bad man as a probative of their defense. Their defense revolved around the ridiculous theory that anyone who ever makes a mistake by dealing with someone who later goes to prison should not be permitted to sue for damages they suffer at the hands of thieves. In other words, it's all right to steal from someone who once knew someone who was a thief. They had no other defense. The court finally ruled that such evidence was irrelevant and would not be admitted, since it would not tend to prove or disprove any material fact. An example, it would not tend to prove or disprove whether the CEO and his conspirator stole the victim's company's trade secret. It's always a good idea to be on your guard for such tactics. Prepare to argue against the introduction of irrelevant evidence. An example, the evidence that cannot reasonably be expected to prove or disprove any material fact. Prejudice may exclude relevant evidence. Where the probative value of evidence, an example, its ability to prove or disprove a material fact. So we're talking about its ability to prove or disprove, is substantially outweighed by the likelihood of confusing the issues, misleading the jury, wasting time, or unnecessarily introducing cumulative evidence. Courts may exclude otherwise admissible relevant evidence. This, of course, a judgment call on the part of the court, and typically will only result when a party objects to the prejudicial evidence. So, as we're saying here, even though the evidence may be relevant, the prejudice may exclude it if it's outweighed by the likelihood of confusing the issues, misleading the jury, even if it's relevant, wasting time, or unnecessarily introducing cumulative evidence. So these are things that may prejudice towards excluding relevant evidence. This, of course, is a judgment call on part of the court and typically will only result when a party objects to the prejudicial evidence. So very important for the party to object. The court's not going to typically act without some type of motion from one of the parties, it seems. For example, the stolen trade secrets case mentioned above. One of the defendants died from a gunshot wound and was found dead in a pool of blood by the side of his car in the parking lot of the court reporter's office, where he was scheduled to give his deposition. Please. Oh, the police said it was a suicide. The jury could imagine otherwise. Clearly, the fact that one of the defendants died from a gunshot wound in such an improbable place as a parking lot, whether the wound was self-inflicted or not, might be probative of material issues related to his participation in the alleged theft of trade secrets. However, it might also shock and mislead the jury. Whether such evidence should come in over objections by the other side is a question for the judge, if the motion to exclude is made. Relevant evidence is often excluded when a party has presented multiple duplicative papers or multiple witnesses testifying to substantially the same thing, so that the material fact to be proven has so sufficiently been proven that further introduction of evidence on that point can serve no purpose other than to make that party's case seem sounder than it is. A dozen witnesses saying a driver was drunk may be more than enough, where a half dozen witnesses have already agreed. As they say, the witnesses are weighed, not counted, and the weight is by credibility, as that's a maxim. The point to be proved is that the driver was drunk. If a party is permitted to put on dozens of witnesses to prove only this single point, it may tend to mislead the jury by masking the fact that the other driver ran a stop sign. Putting on multiple duplicative papers or witnesses should be opposed by motion to limit. See motion in the mind later in the tutorial. Character evidence. This is an area of evidence law that varies from jurisdiction to jurisdiction and gives rise to many errors. Be sure to consult local law for details. In evidence law, character refers to an individual's reputation. An example, what others in the community think of the individual. Example given here is his reputation for honesty, or its opposite. What that individual may have done in the past, example, his prior bad acts, is not the same as his character. Character refers to reputation of an individual. That's what people of community think, not bad prior acts. Very interesting there. And double check on the chat here, make sure it's all refreshed. Yes, indeed. Limune. Yeah, I guess. My Latin's terrible, so definitely don't count on my pronunciations here. Character of party. In general, evidence of the character of a party, or an accused in a criminal case, is inadmissible to prove the party acted in conformity with his character. An example, in conformity with his reputation in the community. So that's our meaning of character in this context, is reputation in the community. Exceptions apply where the party himself raises his character as a defense, because to do so permits the other side to put on contrary evidence to rebut his claims. Character of a victim. Character of victims generally is admissible only if offered by the accused. An example, once offered, the other side may rebut. Character of a witness. The character of a witness generally is only admissible to prove the reputation of a witness for truthfulness or untruthfulness. To prove the reputation, prove the character. The evidence that a witness has been convicted, not merely arrested, for a crime is admissible if the crime was punishable by death. Well, how could he be there if it's dead? Or more than 1 year imprisonment, and if the crime involved dishonesty or making false statements, then regardless of the duration of punishment. More on witness testimony later in this tutorial. Prior bad acts. In general, evidence of past crimes, wrongs, or bad acts is not admissible to prove the character of a person in order to show that, relative to the case before the court, that the person acted in conformity with the character established by proof of prior acts. It may be admissible to prove other things, and thereby may come in so the judge and jury hear all. However, in general, it may not be admitted to prove the witness acted in the same way with regard to the issues now on trial. Proving character. Proof of character, for good or bad, may generally be made by testimony of credible witnesses as to the person's reputation in the community, or the mere offer of opinion. It is permissible to inquire into specific instances of past conduct to prove character within the scope of the rest of the rules relating to character. So, reputation in the community, the primary factor here in proving character. Habit and routine. Evidence of a person's habit or the routine practices of an organization may be admitted to prove that the conduct of the person or organization now under trial was in conformity with the habit or routine practices of that person or organization. Ooh. Note that habit and routine are not character based on reputation. Habit and routine are facts that can be established by competent evidence properly presented and admitted before the court. For example, if it was the habit of a particular party to take a cab home from his local tavern when the bartender refused to serve him past closing, then that habit is admissible to prove the party took a cab home from the tavern on a particular night. Similarly, if the routine practice of a business organization was to deposit its payroll taxes at a particular bank on a particular day of the week, then evidence of this past practice is admissible to prove the business organization followed this routine practice on a particular occasion. The proof here has nothing to do with speculative reputation or character. The proof of habit or routine practice is established in court based on fact, not speculation or opinion of witnesses, and therefore carries somewhat greater weight and is admissible to prove or tend to prove conformity with habit or routine practice, while reputation or character is generally not allowed to prove behavior in conformity therewith. So, character is more about the credibility of testimony, and as we're saying here, the habit and routine is evidence of routine practices of a person or organization that may help one, I guess you'd say, infer that they were doing a particular thing on a particular day of the week, etc. Subsequent remedial measures. Evidence rules prohibit offering evidence of subsequent remedial measures to prove negligence or culpable conduct. For example, suppose the owner of an apartment complex replaces the stair treads on a stairway where a tenant fell to his death after the tenant died. So, subsequent remedial measure. Common sense might urge us to consider this an admission of guilt or responsibility for the unfortunate death. Okay, so that's where our culpable conduct comes in. We think to ourselves, if only he had replaced the treads before the accident, and assume he was under some legal duty to do so. The evidence rules generally disallow for several reasons. First, perhaps the landlord had no duty to replace those treads. Perhaps he replaced them only to prevent further injury to others. The fact he replaced them does not mean his failure to do so sooner was the proximate cause of the death. To admit evidence of his efforts to replace them after the death might be misconstrued by a jury. So the rules generally exclude such evidence of subsequent remedial measures. Can you remember that? Subsequent remedial measures. So because you did something after the fact isn't evidenced unless it was something it was supposed to be a duty prior. It's not going to be evidence of culpability or negligence. Apparently. Let's continue. Double check on the chat here before we do. Yes, please follow Captain Jack's advice. Yeah, and the closest we get to that is our common law here in America. So our American common law is probably our best treasure to preserving a codified natural law. at least the best I've seen it so far. All right. So, again, rules generally exclude subsequent remedial measures as evidence. Second, the law does not wish to discourage individuals from taking such remedial measures when safety to others is in jeopardy. To allow evidence of remedial measures to come in as proof of liability for an injury that resulted prior to the remedial measures might encourage people to leave things in a dangerous condition, lest their attempted repairs be used as evidence against them to prove they were negligent in not having acted sooner. Therefore, it is contrary to public policy to allow such evidence to come in for the purpose of proving negligence or culpability. Okay, so this is an important one to be aware of, and it's called subsequent remedial measures. So, rules of evidence prohibiting. So, this would be an objection because of subsequent remedial measures. However, evidence of subsequent remedial measures may, however, be admitted to prove other facts, such as ownership of the apartment building, or that prior remedial measures were technically feasible and could have been employed. As you can see, a clever lawyer may be able to get around the rule and let the jury decide what the otherwise inadmissible evidence may tend to prove. Similarly, offers to pay medical expenses or actual payment of expenses resulting from an injury is not admissible to prove liability for the injury. Public policy outweighs the probative value of such evidence. Also, generally, evidence that a party was or was not insured against liability is not admissible to prove whether a person acted negligently or otherwise wrongfully, though it may come in for other purposes. An example given here is proof of ownership or compliance with law. Offers of settlement or compromise. For similar public policy reasons, evidence that one party offered to settle a case is not admissible to prove that the party's liability for damages. This is an important rule to keep in mind because allowing evidence of settlement offers or discussions at mediation conferences to come before the court can result in a mistrial and judgment for the other side's cost and fees. It is forbidden. Offers of settlement or compromise. Similarly, for public policy reasons, and anything and everything that happens during a mediation conference is not to be heard by the court. It is strictly confidential and not to be heard. The only exception is a case where one side makes an offer, the other side accepts the offer, and the one making the offer backs down. Such situations, either side may tell the court an offer was made and accepted, but that the other side failed to comply with the agreement. Ooh, now that's an important aspect right there. So if something is done in an arbitration, it seems, then offers of settlement or compromise, if they're not adhered to, could be brought before the court, and the results of the arbitration could be admissible as evidence, it seems. Okay, so it says here, at that point, of course, the case is closed, having been converted to an action to enforce a settlement agreement. All right, that's pretty straightforward. And that takes us to the end of this section here of understanding evidence and relevance. And we're going to quickly go through the chat here. If your evidence shows guilty knowledge, it might be relevant. I think this came up recently. Guilty knowledge, I guess it would depend on how you would define guilty knowledge. It might be relevant. And I guess when you get into the more detailed parts of a case, and there are these inferences and things like that that could be made, and presumptions that might creep in, and you want to make sure you're not doing that wrongly, I guess. So details are where it matters in that. That being said, see if there's anything else in the chat here. Yeah, it's not refreshing. Give me one moment here. All right. Well, I thank everyone for showing up here. And Captain Jack and Bill Thomas, always a pleasure to have you guys coming in here and giving some good input and keeping the chat moving along. I hope all of you will show up for the next one where we're going to get into the next section, which we'll take a sneak peek here while you all are here. And it is privileges. So privileges will be the next episode. That's your sneak peek. And for everyone staying here, I appreciate it. Salute to you all for spending the time to dive deeper into evidence and evidence law and how we can use evidence in a more meaningful way for certain actions that might have to come before others to ensure that the truth is being brought forth and acted upon accordingly. And the best use of our courts. And of course, all of this is summed up through the maxims and the root of our common law. So, again, salute to you all, and I hope to see you all on the next one. Peace out.